Right, so this is part 2. So we're looking at the Senior Courts Act, the Treaty of Waitangi, and the criteria for leave to appeal. So you'll find that in my cases here, this has all been put in. It's a pity that they've put in two. See, it's interesting that they've put in 2A, 2B, but they have not put in they have not put in 74.3, which I have quoted many times.
Yeah.
So they have not put in the 74.3. So that's an issue. So let's just wait and see. So we'll go back to our case. So the 14, the respondents also says that it is not necessary in the interest of justice for the court to hear and determine the proposed appeal under that 74 1A and 74.2, and then I had opposed that under 74.3 under the Treaty of Waitangi. All right.
Mm-hmm.
So the first, the proposed appeal does not involve a matter of general or public importance, which we've discussed how they're quite wrong, don't we, Sharon? We might just review in case the other video doesn't come up. The importance is our 1688 Bill of Rights gives us the right as individuals in our pseudo-law to go to the court without lawyers and ask questions if the ministers are making regulations repugnantly. Yeah, almost finished, sweetheart. First, the proposed appeal, the principles applicable, and that comes under 15, section 72A. The principles applicable to an application for an extension of time where there is a right of appeal are settled and applicable for 43.2 of the Court of Appeal rules. The applicant has not provided any cogent reasons why the Court of Appeal erred in applying those principles in this case, which I don't know that I agree with them, because I said that they erred because they did not look at the conduct of parties, that they refused to engage with me again and again and again and again. And the Court of Appeal omitted. My whole application was based on the conduct of the parties, and they only looked at length of time and reasons for the length of time, and they did not look at the conduct of parties, and that's where I said that they have erred.
Yeah.
Yes. So he said that my reasons are not cogent to 43.2. So I don't know. The proposed appeal, he says, is futile, as the strikeout appeal has been deemed abandoned. Oh my God. So it's same argument, Sharon. An appeal deemed to have been abandoned cannot be revived. It is in the interests of justice that this litigation not be further prolonged. So it was not. It was only that and I already called the Court of Appeals, and this is correct. The appeal was deemed abandoned, and so they sent a letter to the respondents saying that the appeal had been deemed to be abandoned. If I had not put in papers to oppose that, then it would have been abandoned. But since I put in papers to oppose the abandonment, then it continued to remain extant until the Court of Appeal ruled that it was out of a time. So it was still in discussions. Had the Court of Appeal changed their minds and said, no, it's not out of time because of these reasons, then the letter of abandonment would have been overturned and the whole thing would have been revived. So,
Yeah.
so it could have been revived. He is not talking the truth there, in my opinion.
Yeah.
Because if Judge Goddard, if Brown and Katz had said, it is not abandoned, that we, well, Brown and Katz said it is abandoned because the Supreme Court has mooted you. Since the Supreme Court has mooted you, then we will continue with the abandonment. But the moot came before the oot.
Yes.
Yes, so you see how they twisted all this up.
Yes.
So this court has already determined that if the underlying proceedings had any public interest value, that has well been diminished by the deficiencies that led the High Court to strike out the claims in that court. Now, here again, this is a direct quote from Alan France. Alan France said that the High Court strike was correct. But I don't see how she could say that because that was on appeal in the appeals court also and had not been ruled on.
Yes.
So how could she determine that if the appeals court had not even determined it?
Absolutely.
I don't think that she could determine it. That's the same as the moot. They mooted me before the appeals court had decided that it was out of time. So both of those cases are in dispute, and that's what Peter Gunn says is irrelevant.
Oh gosh.
Yes, I know. His Honour Cook J held the allegations in the statement of claim are unintelligible, and to the extent is possible to discern the allegations, many. He only says many, but not all. Many are not within the jurisdiction of the court, and that is exactly what I said. But some of them are. So that is exactly why it should not have been struck, because many of them were not in the jurisdiction of the court, but some of them were within the jurisdiction of the court. And you can clearly see, so that is the Sixtus versus Dern 1-1, and if you go to the Sixtus versus Dern 1-1, you can clearly see, in my opinion, it was within the jurisdiction of the court to do pray a declaration to the effect clearly stating the applicant's ancient 1688 subject right under Almighty God exists pursuant to Section 28. So I had only asked for a declaration that these rights existed, and I believe it was the courts, within the court's jurisdiction, to decide on Section 55 of the 1993 Electoral Act and the Section 55AA that was inserted. Section 55 of the 1993 Electoral Act says that foreigners can work in our parliament, and Section 55AA says that they can work in our parliament even though it says they can't in Section 55. So that the two laws are repugnant to each other. They don't match, Sharon.
No, they don't. And we determined that a long time ago.
Yes. Section 55 says foreigners cannot work in our parliament. It's repugnant to the Treaty of Waitangi, and it's repugnant to the 1688 Bill of Rights, supremacy law. And Section 55AA says that they can work in Parliament. So they're not, it doesn't match, Sharon.
They're contradicting one another.
They are. They are. And I believe that the court could, it was within the court's jurisdiction to explain that to us, the public.
Yes.
We do have the right to have that explained to us.
Yes, we do.
We didn't actually say that one was right and one was wrong. We asked the court which one is right and which one is wrong. And they are within their jurisdiction. But what I accept, we included in the memorandum after meeting with the council, we said that there was a number of challenges to the government initiatives which she argued were being introduced, which amounted to psychological waterboarding by the Parliament, and then we listed all of our grievances. And it is correct, he perhaps did not have jurisdiction to make any rulings, but we never asked for any rulings. We just said that these were part of our grievances. And LexisNexis. We made the allegations concerning LexisNexis and all of these other things, the Sustainable Development Goals of the United Nations, the Mormon temples being established in New Zealand, which is endangering our Protestant religion. It's repugnant. And the United Nations Declarations of Rights of Indigenous. I wouldn't mind betting that guy's come to New Zealand because of this case. Reckon he's coming up under the tents, Sharon.
Are you talking about that, what's his name?
Yeah, I am talking about what's his name. Did I post it to you?
Yeah.
Where is it? Did I post it to you in the...
I'm looking.
Here, I've got it.
Okay.
Now, look who's turned up in New Zealand. You know, they have all their cockamamie lies, but look who's turned up in New Zealand is the UN expert. Put that over there. The UN expert has come to New Zealand. The United Nations Indigenous expert. Can you see that? Oh, you can't see it, Sharon.
No.
The United Nations Indigenous expert has made the visit to the South Island to talk about its obligations in the Nelson tents. But what it says here, the UN Special Rapporteur on the Rights of Indigenous Peoples, Francisco Tizay, met with representatives over the tents. But he goes on to say, there's Claire Charters talking about the customary rights. He's an expert on international law as it relates to the Indigenous people. And so he's really bringing that lens to this issue. And he said, we believe that it's really important for this government to understand its obligations under the United Nations Declaration of Rights of the Indigenous peoples. Now, that has been part there, we have put in our complaint that the entry of the government into the United Nations Declarations of Independence, it was supposed to be a non-binding law. And it's supposed to be non-binding, but they are making it binding by putting it all through our domestic law.
Yeah.
And so it's interesting that he's turned up to remind the New Zealand government that they have obligations under the United Nations Declaration of Rights of Indigenous People, the UNDRIP. It's interesting that he's turned up now, Sharon. You can bet.
Yes, well, I suppose they were getting scared of this government overturning everything, in which, well, they haven't quite succeeded where the Māori is concerned.
Yes, exactly, because now the Parliament...
That could be the reason why.
It certainly could be the reason why, because why is he turning up right now at this point of time where they're going to make a Supreme Court ruling about whether we've got a case or not?
Yeah.
And then it's the New Zealand Parliament has just recently started talking about not being obligated to those rights. It was supposed to be non-binding. They said that it would be non-binding on New Zealand domestic law, that through the 1990 Bill of Rights Act, that New Zealand would consider it when it was making their laws, but it would not be mandatory to them. And now they're turning around and saying that we're obligated to them when we are not obligated to them and never were.
Yeah.
And so, but it's possible that the courts didn't, getting back to the courts, it's possible that they did not have jurisdiction on this issue, but they certainly had jurisdiction, Sharon, on the prayers.
Yes.
On prayer 2 and prayer 3, they had jurisdiction on both of those, did they not, Sharon?
Yes.
They did.
Yes.
And so if we go back to the we'll put him out. So if we go back to the we're almost finished. We're at the end, dear. So that is what he said. That is what he said. That what did he say? The where did he say that, Sharon? The court. Where did he say that they had no jurisdiction? Where did he say they had no jurisdiction? The appeals application to enact...
Was that on the last part?
Is it further down? Yes, that's what he says. His Honour Cook J held the allegations in the statement of claim. He said this has come from Judge Alan France. The underlying proceedings, meaning the first case, was diminished by the deficiencies of the High Court, where Cook J held that the allegations in the statement of claim are unintelligible, and to the extent that it is possible to discern the allegations, many, but not all, are not within the jurisdiction of the court. And then, as we've just clearly shown, that there were 2 prayers that certainly were within the jurisdiction of the court. They could have given me a declaration of right, and they could have addressed the Electoral Act, Section 55 and Section 55 that says no foreigners allowed, and Section 55AA that says that foreigners are allowed.
Yeah.
They could have addressed that. They did not even have to say that I was right or wrong. They could have just said that this is the reasons that it is like that. And they should have said that we agree with the 1993 electoral law.
They should have explained themselves.
They should have explained themselves about that particular prayer, shouldn't they?
They should have.
And that was within the jurisdiction of the court.
Yep.
Even if the 10 grievances, LexisNexis, the Mormon, the Latter-day Saints taken over, and actually it's the Jews, the Muslims, and the Latter-day Saints, and the Catholics overriding our Protestant laws. Even if they couldn't rule on that, they could have ruled on the electoral law, given answers to the electoral law, could they not, Sharon?
Yes.
They
could have.
Yes. We're at the end. There's the signature, so we're at the end, Sharon. The ongoing costs to Miss Sixtus and the Crown. Miss Sixtus continues to incur substantial costs by filing further applications before this court, and the Crown is incurring costs responding to these applications. The respondents invite the court to consider exercising its powers to decline to accept future filings related to this proceedings. Now, Sharon, this is important, what he said here, because Winston Peters got prosecuted by the Serious Fraud Office 3 times.
Yes.
And 3 times the Serious Fraud Office was told that they were wrong by the court. But, yes. And so Winston Peters, in the final ruling that you just told me the other day, I didn't know this, but you told me this. In the final ruling, the Supreme Court, I imagine, said to the Serious Fraud Office, we will not accept any future filings from you in regards to this case.
Yeah.
So it ended everything right there, didn't it? And Peter Winston was in victory, right?
Yes. Yeah.
But that is depending on if throughout the proceedings the court was always given reasons why the Serious Fraud Office was wrong.
Yeah.
But that is not the case with me, because the court from the very beginning have never given me reasons.
Yes.
They clearly admit that some of the things were within the jurisdiction and some of the things were not.
Mm.
Is that correct, Sharon, do you think?
Yep, that is correct.
That is correct. So it's the pieces of my case that did have the jurisdiction of the court that should have been accepted. The court, if the Crown Peter at the meeting that he refused to meet at the last minute, if he had discussed the scope of the court case in the meeting as he was supposed to do, all right, then we could have gone to court just on those issues that the court
alone
had jurisdiction, yes. But it was his refusal to meet that's why I'm talking about conduct of parties. It was his refusal to meet that had caused us not to be able to get the things that did have jurisdiction into the court. That's conduct of parties, Sharon. Now, this is a very serious thing that he has used, because if the court can decide within 10 days or 20 days, the court can say, we disagree with you, there's no jurisdiction in the High Court, we disagree with everything. If the court says all of that, and then they've said that they will not, if they refuse to accept any future filings, that's the end of our case within New Zealand.
Yep.
It's not, however, the end of our case going to the European Union. With our Treaty of Waitangi, which the European Union is included in the Treaty of Waitangi.
Yep.
Isn't it? Isn't it, Sharon?
Mm-hmm.
So it would depend. I'm not saying that I would go to the European Union with the Treaty of Waitangi
And another option.
yes, and our
Hey.
1688. But what it will mean is it's not going to be bad. Now, I'm just going to prepare all the public. It's not going to be bad if the court does say that they refuse to accept any future filings, because what that
Yes.
means is that we have exhausted everything that we can do has been exhausted within New Zealand, and we now must use our Treaty of Waitangi to go into the Supreme Court, into the European Court, and ask for our Declaration of Right at the European Court.
Yeah.
Because that's basically what it all comes down to, is this prayer that we would like to have a declaration to affirm that our 1688 Bill of Rights are still within our grasp. Because if it's not, then why don't they remove it?
Yes.
It should be removed from the laws. They can't have it.
And that's the thing about that 1688. The government can use it. Why can the people not use it?
If you go onto the previous video that I already did, and I'll post up as a link with this one, if you go and see here, linked up, here's all the laws that the government wants to use. Here they all are: Human Rights, Bill of Rights Act 1990, Constitution Act 1980, and there's no imperial laws. So this is all the laws that they've said to you, the public. They've said to the public, these are the laws that we will allow you to use. This is what we'll allow you to use. But look what they've...
Those are the laws that the public have to abide by?
Yes, these are the laws that they will let you use in the courts. And under these laws, there's no right to petition the king, and there's no right to call the ministers into the court to hold them to account as an individual. You can only do it as a group. You can't come in as an individual. But look what, and they've said the public can use these laws only as a group. Well, if you're not part of a Maori tribe, you're not part of the indigenous rights. If you're not part of the Jewish Torah laws, you're not part of the Islamic Quran laws, so there's all the groups. You're not belonging to any Catholic religion. You don't have a group. You've got no group, Sharon, and so you can't. These laws are useless. But it's exactly what you just said. But the government have said they've buried it away deep over in here, where the government have turned around and put, these are the laws that the government is using. The parole acts, the electoral acts, and then under these laws they've put the imperial laws, only for themselves to use. For themselves. So they say. But it is actually, that look how far they've buried it. There's our Bill of Rights, right there in all its glory. So that is it right there. And they said, we can use it, but you can't. And so there's all our rights. There's our right to petition, that it is the right of the subjects to petition the king, and all commitments and all prosecutions for such petitioning are illegal. Says it right there, Sharon.
Yeah.
There's our freedom of speech that Hamza Yusuf over in Scotland has given under the human rights a law that you cannot have it, that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place. It says here freedom of speech, and then that freedom of speech belongs to us, all of us.
Yep.
But then it says, and debates, that belongs to us. Freedom of speech and debates, that belongs to us. Then it says, or proceedings in Parliament. Or, so there's two groups of people. One is us, the people, and one is them, the Parliament. But they've said it only belongs to Parliament, freedom of speech in Parliament. So that's all in there. And there's the supremacy law. I do declare that no foreign prince, person, prelate, state, or potentate has or ought to have any jurisdiction, any power, any superiority, any preeminence, any authority, ecclesiastical or spiritual within this realm. So help me God. Well, that just comes
Well,
down.
why have they put that supremacy law when they've gone and made it repugnant against the free speech one?
Yes.
If only the Parliament is allowed to use it.
Yes. They've said that you can only use that free speech protection in Parliament through the Winston Peters case. They called it parliamentary privilege. So that's
it.
That's as clear as a nutshell, isn't it?
It is.
So they have basically said that you can't. They've basically said they've. This is what I'm talking to you about, the palace being surrounded by thorns and everybody's asleep, but they don't know that if they fight all through the thorns, as Kate Floss, the prince or princess on the horse, fought through the thorns to the imperial laws, right? So if you fight through the thorns to the imperial laws there, but that's all surrounded by all these laws. They said that you can use all of these ones. You're not allowed to use that one. So that's about the end of. Are you able to have your picture on a bit, Sharon, or not? We have the final round, finish up of this. All right.
Oh.
So that's it all in a nutshell there, Sharon.
Yes.
What we're doing. Yeah. So that's clear to you, isn't it?
It is.
So this is a huge case. I don't know where they get the no public. This is huge, but it's all set out beautifully for them to take or not to take.
Yeah.
And so that's what we're waiting for next. We've put up the prayer. They have not put in any acceptance that they agree to come to meet. I've put in the application for the 20th to the 24th of May. And then they have not put in any application for a fixture of time. So the court is going to decide if there's going to be a fixture. And I've asked for an oral hearing to defend the right to. I've actually asked for an oral hearing to go in and defend the right to have this case accepted into the court. So that's, the case is not accepted in the court. That's where we are, where the court's going to decide if they will accept it into the court for the big holy battle, or if they will not. That's one. And number two, if they will accept an oral hearing to allow us to battle about whether it's going to be accepted or not. So that's the decisions that they'll be making now. So or they could just say, it's done, we're not accepting anymore, it's done, you're out. So we'll just have to wait and see, Sharon.
Yes.
Won't we?
Yes.
We've done good, haven't we?
We really have for 4 years, nearly 4 years, Kate.
Since the 2021 COVID response, what started out as a tiny opposition to the COVID Response Act that forced us to be locked in our homes, locked out of our jobs, forbidden from entering our country. Since that tiny little case, it has evolved into a huge holy battle, hasn't it, Sharon? So do
They
not,
certainly have.
yes, so if you're into your pseudo-law and you think that you can't do it, believe me, from a tiny little seed of a case can evolve a great holy war under Almighty God and the protections of Almighty God. It can all evolve from a tiny little seed, can't it, Sharon? And that's what we've done.
And we've proved it.
Yes.
You've proved it. We've proved it.
And so it's not a matter of winning or losing. It's a matter of going into the court and having the bestest judges and having the parliament look at what your issues are. And obviously ours were all dealt with because they have been dealt with. But, you know, just getting her...
Yeah, through another avenue, they have been dealt with. The only thing is we never got a declaration out of it.
We did not get the declaration. We got all the 10 grievances were addressed in Parliament by Winston Peters. The investigation into the drafting laws was addressed by Judith Collins. The prayers have been put up in the government website and everybody knows about the 1688 Bill of Rights now. But we did not get our declaration, which is what we're after, Sharon, the Holy Grail.
Yeah, that's what we were after.
That's the Holy Grail, isn't it?
Yes.
Together with the Treaty of Waitangi, to finally, after 280 years, to bring this, is it 280 years? To bring this Treaty of Waitangi together with its partner, the 1688 Bill of Rights. There's the partnership right there, to join them together and finally recognise this article, the preamble and the Article 3 must be recognised.
Yes.
By everyone. And
absolutely.
And the United Nations chief is in New Zealand to fight against it.
Yep.
That's why he's here, I reckon, Sharon. Right.
On the sly, I think you could be right.
On the sly, I think I could be right.
Mm-hmm.
Right. See you later, Sharon. Thank you, my dear. High five.
See you later.
Bye-bye.
Bye.
Thank you.